I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's... we will file a written response. My understanding is this court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so
right.
I'm just wondering.
I mean, honestly, the next couple of days we're going to be busy with picking a jury, and maybe even longer than that. So, I mean, I don't. As long as I rule on it, yeah. As long as I rule on it in time for you to make the appropriate edits, and I don't ruin, you know, the poor IT person that's going to be tasked with doing the edits. Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Well, great, thanks.
But the good news is like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this. So
curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. Well, attorney.
No,
there are some statements that you did not ask to be, and so.
From Tracy Minor, Judge?
Yes.
Well, then that was an error. That's the highlight didn't carry through.
Okay, all right.
Because, and I don't want to interrupt the Commonwealth, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right, I appreciate that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from it, moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid, and finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview, and I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth, as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you,
Yes.
and just now go take those highlighted and maybe color code all of these statements they've listed, wouldn't it make it easier for us all?
Well, I think we can get down to I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts, once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row, so then he's just shouting numbers out, and it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence, but I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right?